All rise. Court is now in session. The Honorable William Stone presiding.
Good morning. Please be seated.
Mr. Tommy Lucas next. He's going to be an inmate. On Mr. Frazier's case, we're requesting a continuance. Do you have a May date that you could get, Your Honor?
Yes, the
May dates are at 2:30, if that's okay with you.
At this point, I believe we're close to a resolution, but we would like to set it for an evidentiary anyway, just to make sure it's finalized next cycle. I believe we are close to a resolution, but I'm going to go back and get it set just to make sure.
May 15th, May 22nd.
We do the 22nd at 2:30, was that?
that's acceptable.
And if we do have a resolution, we'll just contact your office, see if we can get it separately, if that's okay, Your Honor.
Absolutely.
Thank you. Next will be Mr. Tommy Lucas. Your Honor, Mr. Lucas is here on violation.
Ms. Kennedy, County Clerk, do you need something else from us, or I think we're finished with y'all, unless you need something from me if I miss something.
I think they're done. I saw Patrice Cashwell, it kept getting stuck, and then it would reconnect, and then get stuck, I don't know.
Okay, well, we reset it for a status on May 15th.
Yeah, I just sent a message to let her know that, yeah, I mean, we're done.
Okay, all right, well, thank you very much, I just want to make sure we got it.
Courtroom, I don't know why it wouldn't. My line was up, but it would not let me do anything, so.
Well, we are having some technology issues, so that may be it. I'm sorry, go ahead, Mr. Duda.
Yes, sir. Mr. Lucas is here on violation of probation. The underlying basis for the probation is a new law violation in Walton County. Just received a discovery from Walton County a couple weeks ago. I haven't been able to discuss the matter with the prosecutor there. Essentially, attempting to get a local resolution with the new law would be Ms. Matthews has been on a work training for the last week. We request a continuance to see if we can get something worked out on this one, Your Honor.
All right. State?
No objection from the state, Your Honor.
The next regular docket, is that what we're saying?
I think that would be good.
Madam Clerk?
So you want retrial today or
No, these are VOPs.
June 12th?
June 12th.
June 12th.
And
And
if
of
you
course,
have,
we get
or
something.
if you have a resolution sooner, just advance it.
Thank you, Your Honor.
All right.
I believe that's all I have, Your Honor.
That's all I show. Thank you, Mr. Durrell. Ms. Jacob?
Thank you, Your Honor. The first I have is Jarius Hill. Mr. Hill is an inmate. Your Honor, if I may just skip ahead to Mr. Rodriguez, who's in the audience and approaching.
Ms. Evan Rodriguez,
Yes, sir.
24-511 and 24-510.
Correct.
All right.
And Your Honor, Mr. Rodriguez has reached an agreement with the state. He's going to be pleading no contest as charged to both cases. He'll be adjudicated guilty, placed on 1 year of community control, followed by 2 years of probation on all felony counts, and it'll run concurrent among all the felony counts. All misdemeanor counts will be an adjudication and time served. He will need to pay $1,140 in court costs in case 510. He will need to pay $615 in court costs in 511. There'll be a total of $250 cost of defense. He'll need to submit to a substance abuse evaluation within 30 days. He will need to begin any recommended treatment, if there is any, within 60 days. He'll have no controlled substance without a prescription and no alcohol with random urine and breath testing. He does need to complete 100 hours of community service work and maintain gainful employment or show proof of 2 job applications per week. And it's the same terms and conditions for both cases, other than the difference in the court costs and whatnot. May I approach?
Granted.
And we have no objection to the score sheet.
Is that the state's agreement in this case?
Yes, sir.
All right. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. You heard what Ms. Jacob said, you signed the written plea form?
Yes, sir.
And how old were you and how far did you go to school?
32, I got my GED.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read what Ms. Jacob just announced to me?
Yes, sir.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, sir.
And that says to me you believe the state has the evidence necessary to convict you of these charges and you're not going to contest that?
Correct.
You understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove you guilty.
Yes, sir.
And in this case, adjudication,
He'll be adjudicated guilty.
the plea form is just a little bit different than those two. So you'll be adjudicated guilty of these charges, and you'll be on a year of community control followed by 2 years of probation with some additional conditions beyond those that are standard, which is the evaluation within 30 days and any treatment within 60 days, no substances without a prescription, and random testing to prove that, get a job, or show proof that you're looking for a job. And if you are looking for additional training, then the court would say that is approved also as part of your job looking. So if you say, I want to go back to school and get a new trade or whatever, then the court would find that's an acceptable alternative as long as you're doing something to advance yourself towards gainful employment.
Yes, sir.
Ms. Jacob answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with how you've been represented?
Yes, sir.
All right, I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. Please score sheet objections.
No, Your Honor.
Okay. If you step over this way, have your fingerprints down, please.
Hill.
Your Honor, this is Jarius Hill before the court in 24 CF 2280. Your Honor, we have reached an agreement with the state in which Mr. Hill is going to be pleading to a lesser included offense of grand theft in count 1 and as charged in count 2. He will be adjudicated guilty, placed on 1 year of community control, and be followed by 2 years of probation, concurrent to 24 CF 872. He will need to pay $515 in court costs and to obtain a GED or complete 100 hours of community service work within the first 2 years of supervision. No trespassing at Bob Sykes Corner Market at 100 Bob Sykes Boulevard in Fort Walton Beach. He needs to complete an anti-theft course, maintain full-time employment, or show proof of 2 job applications per week, with the understanding that if it's in GED classes, that would substitute. No controlled substance without random urine and breath testing, and no contact with Hayward Reeves. And if I didn't mention already, counts 1 and 2 will be concurrent to each other as well. And Madam Clerk, the statute number is 812.014, sub 2, sub C, sub 1 for that lesser included offense. Thank you. You're welcome. May I approach?
Granted.
Oops, sorry.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. You heard what Ms. Jacob said, and you signed the written plea form?
Yes, sir.
All right. And how old are you?
22.
Did you do that before you signed it?
Yes, sir.
And is what you read what Ms. Jacob just told me?
Yes, sir.
Do you understand by this plea that you plead no contest to the announced charges?
Yes, sir.
And that says to me you believe the state's got the evidence to convict you and you're not going to contest that?
Yes, sir.
You understand by making this plea, you're waiving the right to a trial by a jury, what's saying that?
Please make sure all cell phones are off.
That's a good reminder. I'm gonna check mine too. I like that ringtone. All right, so you understand that by making this plea, you're waiving your right to a trial by jury.
Yes, sir.
All right, and in this case, you're going to be adjudicated guilty. You're going to be on year of community control followed by 2 years of probation. And this concurrent with the other case that you're on. And you got the fees and costs that were discussed. In addition to the standard conditions, you got 100 hours of community control, and you got to, or you complete your GED. Within the first 2 years. You can't go back to the corner market, and you've got to do the anti-theft course, and you've got to get a job or show proof of your applications. Now, I guess the court's concerned that if we're asking him to either get his GED or but at the same time we're asking him to, you know, I want to be sure I'm not setting him up for failure. I'd prefer to see him finish his GED or his education. So would the state be willing to modify that to say as long as he's in the classes for his GED, he doesn't have to do the employment search?
That's the intent. We want him, if he's not in school, we'd like him to be employed.
Okay. All right.
Yes, sir.
So if you're doing your classes towards getting your GED, I'll waive the requirements that you're searching for employment. But if you don't do that, then you've got to search for employment, and if you don't get your GED, you got to do the 100 hours. Okay? And so if you want to choose, say, some sort of trade where you could get your GED plus a trade certificate, then I'm willing to continue to waive your employment requirements as long as you're advancing yourself. So some of those trade classes will help you get your GED and teach you a trade. So if you want to do that, I'll modify it further to say if you're doing something like that, then you don't have to do your job search as long as you're in school and you're progressing. Then I'm good with that, because the goal here is to set you up for success, and that's one of the ways it will happen, okay? So you understand what I'm saying?
Yes, sir, I understand.
Okay, all right. And then no substances without a prescription, and you'll have testing for that, and no contact with the named person, and in addition to the standard conditions. Now, with that, has Ms. Jaquith answered all your questions about the plea and how it affects you?
Yes.
And are you satisfied with how you've been represented by Ms. Jaquith today?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
And would the court waive the cost of supervision as long as he's either advancing his education in some manner, whether it be GED or GED trade?
Yes, as long as he's actively engaged in those pursuits, the court will waive the cost of supervision.
And Your Honor, finally, I have Alexander Mararu. And that case number is 25 CF 387. Your Honor, we do have an agreement with the state. This is a little bit odd. I've already made probation aware. There is an immigration hold, and very likely, based on the fact that we know that his wife was picked up by immigration, he will also be picked up by immigration. He understands that. He understands. We have extensively discussed the potential impacts this plea would have on that immigration, and I think he's actually in a position at this point, he's willing to waive the immigration, waive the waiting period. So he's going to be working towards that. So I just want to make it very clear on the record that we have discussed that at length, and to the extent that I'm able to tell him what will happen, we have reviewed that. And even with that, we are still prepared to enter this plea today. It will be a no contest plea as charged, be a withhold of adjudication, 2 years of probation to run concurrently with one another, $40 per month cost of supervision, $515 in court costs, a $150 cost of defense. He does need to complete 48 hours of community service work. He needs to pay restitution to Jean Cardoni, that's Jeancardoni, and/or M&T Bank. We're not really certain what happened exactly yet, Judge. And we'll reserve jurisdiction for 120 days to determine the amount and the correct payee. It is joint and several with the co-defendant once that restitution is established. May I approach?
Granted.
And there's no objection to the score sheet.
All right, raise your right hand for me, please.
Yes.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your
All right, you can put your hand down. You heard what Ms. Jaquith said, and you signed the written plea form.
Honor. Yes,
How old are you?
36.
And how far did you make it in school? How much education do you have?
It's a little bit different.
It's
12,
different.
high school.
Okay. Are you able to read and understand the plea form?
Yes, Your Honor.
Now, from this discussion, it's apparent that English is not your first language.
Yes.
Are you proficient enough in English to understand the plea form?
Yes, I understand.
And is what you read in the plea form what Ms. Jaquith just announced to me?
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges? And by pleading no contest, what I understand you to say is that you believe the state has the evidence necessary to prove your guilt, and you're not going to contest that. Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt? And according to this plea arrangement, you'll be adjudicated guilty of these charges.
Of withhold adjudication.
I'm sorry. Yes, it is a withhold of adjudication. Sorry, no, it's okay. It's a withhold of adjudication. You'll be on 2 years of probation concurrent with the counts. And you'll have some fees and costs that I'll have to pay. You'll have the restitution, which may be established within 120 days. And that will be joint and several. Is that what you understood to be the plea arrangement? Now, Ms. Jaquith has told me very carefully that she's discussed with you, based upon your legal status, the consequences of this, and you're nevertheless willing to go forward with a plea. Okay. With that, has Ms. Jaquith answered all your questions regarding the plea and how it affects you? And are you satisfied with how you've been represented?
Yes, Your
The court will find the plea to be freely and voluntarily entered into, and will accept the plea with the withhold.
You're welcome. That's all I have, if I may be excused.
Yeah, does the PD expect to withdraw from any cases that you can, so Ms. Jaquith can be introduced to her clients today and make progress?
Judge, we don't anticipate any withdrawals today.
Okay.
May I approach really quick?
Yes, ma'am.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the
All right,
courthouse. in
Mr. Hardy.
Good morning, Your Honor.
Good morning, Mr. Hardy.
Your Honor, I've got Armando Romero Oriano, 24 CF 1667. And Your Honor, we were set for a plea this morning, and Mr. Romero is not here. I spoke with him on Tuesday. We were supposed to meet today at 8:45. I don't know if he's been picked up by ICE. It's very rare for him not to instantly respond. But I have messaged and called him all morning.
Was that something that, be precise in my language, was that something that had been a contemplated outcome with you, Mr. Hardy?
We had discussed the possibility of that. We had worked out a plea for probation, withholding probation today. And everything was good. I'm not really sure where he's at.
because just briefly looking at the progress docket, it appears that I think the state would agree that he's been reliably present.
He was here even last court date, Your Honor.
So what's the state's ask?
You know, based on Mr. Hardy's representation that they've had complete communication during the whole process and he's been here, I wouldn't object to, you know, putting it at a different date so he can locate his client.
You want to just move it off to the, what is it, 24th?
22nd, 27th.
Don't we have one on the 24th? Yeah, we'll put it on the 24th next week.
Perfect, Your Honor.
And if you can reach, just move it to then and maybe you'll have more information.
Thank you, Your Honor, I appreciate that.
Anything else for you today?
No, Your Honor, that's all, thank you.
All right, Mr. Patel.
Good morning, Judge.
Good morning, sir. I know you've got your interpreter, is that correct?
3 matters before the court. The first one involves an interpreter. With 2 defendants, should I call them both up, or do you want to do them individually?
Let's make the best record we can unless it's a simple,
I think it's simple.
okay, call your clients.
Okay. Jay Patel on behalf of Brad Stewart, both of his clients is with the last name Lee and Kee Chow rather. You go come up.
Good morning, Mr. Interpreter. Would you raise your right hand for me, please? Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing?
I do.
All right. Mr. Patel, you may proceed.
Thank you, Judge.
Be slow for the benefit of the interpreter now.
Thank you.
As I stated, Jay Patel on behalf of Brad Stewart, on behalf of, spelling is L-I, his last name, first name is J-I-N-H-U-A, 22 CF, 3180.
好，我们这边由这个 Brad Stewart， 这位被告是李金华他的暗号是22 CF。
Mr. Stewart's other client has the last name Q-I-C-H-A-O, first name G-O-N-G, 22 CF 3196.
另外一位他的客户叫做 QI-CHO， 这个是一样的，他的暗号也是在刚才上列的名下，是1022 CF 003180。
Rather, Judge, I made a mistake. This gentleman's last name is Gong, not, so it's G-O-N-G is his last name, should be on the docket, I believe. It may be, actually, I think it's different on the docket.
Yeah， 法官大人刚才可能做一个错误的一个命名这个应该是姓龚如果在我们的docket 上面应该有写的。
I would ask that you engage with Mr. Stewart and have Mr. Stewart engage with the clerk to be certain that the names are correct.
那我建议你跟 Stewart 这个律师呢来跟我们的书记官那边来核实一下来改正，如果有错误的话。
It may be as a result of the charging instrument.
也许呢成为可以帮助他能够把这一个案子呢可能可以解决掉。
But it's important that it's properly reflected. So if you would engage and also with the state.
但是呢，不管是结果如何，是非常重要的，要把名字做得非常正确的，否则的话会有错误的。
Judge, one of the challenges that I foresee is that they're both before the court on a petition for expunction, based upon how the record is presently. I see the challenge going forward, trying to move the weight of the earth to swap names.
我觉得这个是对我们最困难的部分几乎是不太可能，就好像要把这个整个的地球给把它转过来，要把名字给换过来。
I believe at this time it would be appropriate to proceed forward as the record reflects, so that can be expunged.
那我请法官大人能够让我们让这案子继续进行不要在名字上面来更改的这个问题上确实是很困难的。我们可以早一点把这2位的他们的案子能够清案。
State.
Your
Honor,
the state was gonna have no objection to the petition to expunge for either of these two individuals.
州政府这边呢，并没有什么样子的一个来反对他们他们的名字只要是合乎这个法律上的程序正式的名字是可以的。
Do you know if Mr. Stewart submitted an order?
你知不知道Stewart 这个律师有没有把这个法令有没有把我们提交上来过？
That I don't know, Judge.
当然我不晓得这件事情。
I know that the state is in receipt of a proposed order. What I don't see on that proposed order though is any space for Your Honor to sign.
法官大人这边好像有他们提交的一个提案令但是并没有看到这边有任何签字的部分。
He's probably e-filed it.
Right. I have the order in the 3180 and I'm signing it now.
我这边有一个3180的这个也许他是用的是电子文档来提交的。
And I have the order in 3196.
我这边有的是3196。
And I'm signing it now.
目前我来签这个提案令3196的案子。
And to be clear, the state does not intend to reverse or demur either petition.
That's correct, Your Honor.
Okay.
很清楚的州政府那边并没有收到他们提交的，是的。
Thank you very much. Thank you, Mr. Interpreter.
Thank you, Your Honor. Have a great day. Thank you. Bye-bye.
Judge, you ready for the next one?
Yes, sir.
Jay Patel on behalf of Rhonda Marchman, 19 CF 957. She's present and approaching. Judge, I recall you telling counsel that they're having technology issues and your ability to look at documents is limited. This motion is document heavy.
Yes, sir. I've read this. I prepared for this because I believe I did the sentencing on this, and I read the motion, and I didn't see a state's response on this.
Your Honor, in reviewing, I was not the SA on the case. I went through and I reviewed the record. I also reviewed a more recent order that was signed by Your Honor, I believe, in which not super recent as in, the most recent order that was in the clerk at the time that I could see it.
I understood what you meant.
Sorry about that, Judge. Where the judge stated that it was the intent of the parties that if all conditions of probation were to be met, including a very lofty sum of restitution to be paid to the victims, that it would be the intention of the parties to modify the probation to either eliminate or to suspend the Department of Corrections sentence. I'm also in receipt of a sworn affidavit by the victims stating that they did receive the $150,000. We reached out to explain to them everything, and so at this time, Your Honor, the state would have no objection to modifying the probation to remove the Department of Corrections sentence and terminate the probation, so this case would be finalized.
All right. So, for everyone here who's not, yes, ma'am.
I'm sorry, I didn't catch the name, which is of it.
It's Marchman, M-A-R-C-H-M-A-N, Rhonda, 19 CF 957. So for those who are not aware, what occurred in this case is at sentencing, the court imposed a sentence that this court seldom uses, and it's called a true reverse split sentence, which sentenced the defendant to a period of probation.
And that was based upon a strong recommendation of the victim in the case with a large amount of restitution, with the provision at the end of that sentence of probation that the defendant was then to report to prison. The goal was to see if the defendant in fact reformed, engaged in no further behavior which took advantage of folks, and complied with all the terms and conditions, essentially providing proof is in the pudding, as my grandma would have said, right? And that was, as I said, based upon a strong request of the victim in the case. I don't do it often because it was a departure from the sentencing guidelines. But with the results that have come, the court will agree to modify the sentence and remove the sentence to the Department of Corrections in this case, and say that I thank you for doing that, and that was the purpose of this, to demonstrate that you could comply and correct the circumstances that presented themselves in the past. And I think at this point she was 4 months left, I think, or 3 months.
May 31st.
So a little more. So you'll still be on probation until then, but at that point in time, assuming there are no further violations, no violations until your termination, then you would be allowed to terminate on 31 May without the imposition of the Department of Corrections sentence. That's the only stipulation. No further, there are no violations between now and your termination date, and suspended, the reverse split part of the sentence would be removed.
Yes, sir, thank you.
Okay?
Thank you, Judge.
All right, thank
Judge,
you very much.
would you like me to follow up with an order on that?
Yes, please. Pass it by the state.
Finally, Judge, Jay Patel on behalf of Katrina Puri, 21 CF 388. She is present. Also document heavy for this motion. Did the court have the benefit of reviewing it?
Yes.
Judge, we're before the court on a motion to modify essentially a PTI with the plea. Obviously, the court's had the benefit to review the motion and the accompanying affidavits. It's an unusual request. This whole case has been rather unusual, but here we're asking for limited relief, really for what's in the best interest of her child, and in these formative years while she's finishing up high school. Essentially, and what the court can note in these affidavits is that these young children that are under 14, they're actually the siblings of her friends, neighbors, teammates, and cousins. And so it's really causing a little bit of pain, and it's certainly making it not as seamless as you know, minor purity should have for adolescents. And we believe that based upon these affidavits, the relief that we're requesting is appropriate.
All right. What's the state's position?
Judge, we would object to the modification and allow her to have unsupervised contact with minors. We would note that this was a 4-year PTI with the plea and ask the court to consider the best interests of society as well. We do have safety concerns about her having unsupervised contact with minors under the age of 14. That's why the state made that an explicit condition of her PTI with the plea, and why we're objecting now. The victim in this case was a younger minor, and part of why the victims agreed to the PTI was this contact provision. We did contact them about this modification, and obviously they object as well, as does the state.
apologize, it's taking a little longer using the other system to see the documents, I apologize.
No problem at all. Judge, I'd just like to add that the relief that we're requesting is narrowly tailored. We're certainly not asking for what the state's suggesting, that she wants all kinds of contact with every minor that's under the age of 14. That's certainly not the case.
Well, and I guess reading the motion, Mr. Patel, and that's the reason I'm flipping back and forth. You refer to the attached affidavits, but it's not clear from your motion the exact relief, I guess, without referring to the affidavits. So are you saying that you want to modify it only to have contact with a specific list of minors, and those are the ones, and I'm not using names simply because they're all minors, and I don't want to announce them
Correct.
on the record. So is that what you're saying, that the listed, I think there are, like 7 affidavits, is that right? 6 or 7, 1, 2, 3.
There is, some of the affidavits have both mother and father.
And to clarify, Mr. Patel, it looks like it's 10 minors. Or 11.
9 affidavits.
Some of those kids
Are, right, it's hard to tell with the initials.
What's that?
It's hard to tell with the initials how many.
But some of these kids in the affidavits are over 14, but for the purposes, the parents included all of their kids in this. So how many total? But it's the minors, it would be the minors in these affidavits.
Okay. Because in just reading your petition, it wasn't clear. So what yours, and I've said this many times as a judge, I can imagine thinking about all the drafting I did, having somebody fly spec it like I'm doing yours, and I apologize. It wasn't clear to me. You're saying it's only the children listed in the affidavits that the request for unsupervised contact is being made,
That's correct.
not any children.
Correct.
And the request is being made based upon the parents of those children consenting to that contact.
That is correct.
Because as I read the motion, I understood it to be those were just examples of parents saying it was okay for contact to be made generally, but you're limiting it to those children under any circumstances, not just under the sports or other contact.
That is correct.
All right, Ms. Barrickman, after that clarification, any further response?
Judge, given it's still unsupervised contact that they're requesting with minors under the age of 14, specific minors given you, we would still object.
And I'm not insensitive to the plight that your client finds herself in based upon reading the documents and based upon reading the affidavits. The court is concerned about, however, interjecting itself in between the contract, essentially, that your client made with the state in agreeing to the pretrial intervention. You're now asking for that modification. If the state were agreeable to it, then of course I would enter an order doing that. But if the state's not agreeing to modify their contract, I'm uncomfortable interjecting myself into that environment without the state's agreement. So respectfully, the petition is denied.
I understand, Judge. I have nothing further. May I be excused?
Yes, sir. Thank you. Good day.
Thank you.
Caitlin Laird. Good morning, Mr. Matheny.
Good morning, Your Honor. And again, thank you for letting me appear via Zoom. I'm here in Miami. Eric Matheny on behalf of Caitlin Laird, and it's our petition to seal.
Yes, sir. Does the state intend to traverse or demur the petition?
Your Honor, we just simply want to, we contacted the victims, in this case pursuant to Marcy's law. They are unable to have been present, but they did each write a letter to the court that I would like to read. That is our basis for requesting a denial of the motion of the petition to expunge or seal.
Well, I'll be willing to reset it for an evidentiary hearing, but I don't think I can just take a letter. If the state believes that they have a basis to contest the petition, then I'll set it for an evidentiary hearing and you can bring the victims, but I'm not sure, I don't think the evidentiary rules allow me just to, I mean, I'll give the state every opportunity they believe they need.
Yes, I'd like to do that, Your Honor.
Okay, all right, so what I'll do is I'm gonna set it for a status on the 24th, but you work with Mr. Matheny and with the clerk to set it for an evidentiary hearing on that question.
Yes, Your Honor.
Because if the victims have written a letter and expressed a desire to oppose the motion, then the state should have every opportunity under Marcy's law and under the rules to put that evidence on to provide the victims the opportunity to have their voice heard in court as the law requires. But I'll just put it on for status, and if you reach a time and a date, then you don't need to be here on the 24th, Mr. Matheny. You understand that? But that's the only tool I have to keep the case moving.
Your Honor, and is my continued presence on Zoom permitted by the court?
If we get to an evidentiary hearing, you just have to, you work with Mr. Gomez and see how much time he thinks it is. If it's an extended period of testimony, I might rethink that, but if it's a limited amount of testimony, I'd permit you to still come. But work with Mr. Gomez on that, and let's see how that is. If it's limited testimony, I have no
Thank you.
problem, but if it's extensive, I probably need you to be here.
Understood, thank you.
All right, so we'll leave it on for status on 4/24. If you get a date set for the evidentiary hearing, you don't need to be back on the 24th.
Okay, if we don't have a date by then, is the 24th at 9 AM, is that via Zoom as well? Is that okay for the
Yes.
status?
Yes.
All right,
And if you don't have a date by then, I'll set a date.
Thank you, Judge.
All right?
thank you.
Thank you, Mr. Manning. Good day.
Thanks.
Mr. Cobb, good morning.
Hey, Judge. Good morning.
We have Mr. Rebecki today on your bond motion, is that right?
Yes, sir, I do.
Yes, sir. All right, and they're bringing him out now. Good morning, Mr. Cobb is with us remotely by permission of the court. Go ahead, Mr. Cobb.
Yes, sir, Judge. This is Mr. Peter Rebecki in case numbers 24 CF 938, 24 CF 2711, and 25 CF 13. Mr. Rebecki filed a pro se motion requesting a bond reduction. We had talked about it, and I didn't see that there was a need to do that, but in order to be as safe as possible, I adopted his motion and set it for a hearing. Currently, I believe in case number 25 CF 13, he has a bond of $20,000 on a first-degree felony punishable by life. And then on his other two cases, he has respectively a bond of $1,000 and 2711, and then 3,500 and 938, I believe. The question that I have, judges, on the jail website, it shows that he has a bond denied or a hold on him for a violation of 900.04, which is the contempt statute. And I couldn't find any record of where that had taken place or why the jail website would indicate a bond was denied based on a contempt charge. So from what I can see, it looks like his total amount of bonds for all three cases is $24,500, unless there is a contempt issue that I'm not aware of.
I think that's an error at the jail. I believe what happened in the 938 case, give me just a second, you weren't here earlier, we're having some issues resolving documents on the electronic system, so it's taking me a little longer to pull the documents up, but give me just a second. I believe that he was out on bond in the 938 case, and when he got new charges, then his bond was revoked based upon the 907-046, I believe.
Okay, yeah, that makes more sense.
And I think that the jail website just has a wrong citation. I'm looking at the record of first appearance from, stand by. record of first appearance from 2 January, and Judge Schlechter revoked his bond based upon probable cause to believe the defendant has committed a new criminal offense in the new case. And he revoked his bond on 24 CF 2711 and 24 CF 938. Does the state concur with the court's view of the progress docket?
Yes, sir, the bonds were revoked, yes, sir.
Okay, so I think the jail website's simply wrong about the contempt, reference.
Yes, sir. I had gone on earlier this morning to look at those two cases, but I couldn't load any documents.
Yes, sir.
But I guess Mr. Rebecki would ask the court to reconsider the revocation of those two bonds based on the new charge and reinstate those bonds and release him on the $24,500 total bond amount. He's been in jail since January.
The
1st, correct. And I know that the state's charging him with a first-degree felony punishable by life based on the burglary. But the facts of the case are he's alleged to use a car lift belonging to somebody else. In the process of using it to try to fix his own car, broke it. And that's where the restitution amount comes in that increases the crime to a first-degree felony punishable by life in prison. So I believe Mr. Rebecki is asking the court to reinstate the bonds in those two cases and continue with the $20,000 bond in the new case.
All right, what's the state's position?
The state would ask the court to deny the request, Your Honor. As you were speaking earlier, Mr. Rebecki was first arrested on around April 21st of 24 on a grand theft charge. And he gets out on bond, and then later that year in November, he's arrested on a possession of controlled substance charge and is released again from jail. And then in January of this year is the new burglary charge. And at that point, his bonds were revoked in the first two. Every time that Mr. Rebecki has been let out of jail, he's committed new law violations. The burglary at the Niceville transmission place, there's close to, from what I can tell, it could be up to $20,000 worth of damage. The lift was severely damaged. That lifts the cars up. I've gotten documents from them for repair costs and replacement costs. Mr. Rebecki's score sheet has 108 points just on prior criminal history alone. He's going to score out to probably close to 70 months. DOC, the state would object to any modification of his bond or the reinstatement of the bond.
Your Honor, could I speak?
Well, it's generally not a good idea for a defendant to speak in court, but as long as you're not going to talk about the facts of the case, then if you're just going to talk about your bond conditions, then feel free to.
Thank you, sir. I've been here for 30 years, and I have family here. I turned myself in January 1st when I heard about my new charge coming in. I was on bond, and one of the new charges was before the bond I was even out on, sir. It happened before back in 2023. I've been here a long time. I have a job of 20 years here, and I'm not talking about the lift or anything like that, but it was $3,500 for that, and I was willing to pay for that, but the sheriff's office didn't pay. I turned myself in. Our family has a friend, Chad Berninsky, and he's the sheriff's department in Destin, and I had him pick me up on January 1st. I wasn't trying to run. I'm not a threat to society. I haven't been in that much trouble as what the state was saying. I have been in my younger years, yes I have. But I've had my own place, for 5 years now. I paid rent, and I've been there for
5 years. It's 1919 Bayshore Drive in Niceville, sir. I'm not a threat to society. I've never had a battery on me or anything like that, so I don't know why I wouldn't be able to have my bond reinstated. I can try to pay out on this. When the sheriff, Niceville didn't let me know it was $3,500 for fix this. I didn't know I broke it, sir. I was trespassing.
Don't talk about the
Yeah,
facts of the case.
Okay, sir.
Yeah,
The state attorney's
think
here
that's
and they're
good.
making a recording.
Okay.
Anything you say can be used against you,
All right, thank
right?
you. I'm sorry, Mr. Cole.
Mr. Rebecca, I think that's enough. I think you've told the judge that you have ties to the community, you have a job, you have a residence, you've been here for 30 years. Judge, I would point out that the one case is a possession of controlled substance case, and then the other case involves the theft of a bicycle that was returned. He does have priors, but those priors are, from his youth. I don't think he's had additional crimes other than these between those. And so he's asking that you reinstate those bonds and even do it with conditions of house arrest if you'd like, where all he does is go home and go to work, go home and go to work. And if the court deems that an electronic monitor would be sufficient to protect and to assure that he's not out breaking the law and to assure his appearance on his court dates, I'm confident he will appear and he'll agree to that.
Anything further?
No, sir, nothing further.
State?
No, sir.
No, motion's denied. Thank you.
Judge, thank you for allowing me to appear by Zoom. I'll see you guys at 2:30.
Thank you, good day. Good morning, Mr. Barnes.
Good morning, Your Honor. I've got Sean Muldoon.
Sean Muldoon, please.
And Your Honor, Mr. Muldoon was, he's got a VOP, of course, for a charge here in Escambia County that has taken forever to get to trial for various reasons. It should go to trial here in about another 8 weeks or so. And that's kind of what's holding things up in Okaloosa County. I believe the prosecutor's waiting to see what the outcome of the underlying new law charge is. So I don't know what you want to do today exactly.
All right, State?
I was under the impression that we were kind of waiting because that case could resolve in a way that would be conducive for the defendant with this VOP. If they're moving forward and if there's no opportunity for that case to be dismissed, I think there was some discussion about whether or not the victim is going to go forward with it in Escambia. If they are, what I'm going to do is I'll make sure that I review my case. I will get an offer that includes that VOP charge, and I will get that over to him. If we want to set it, I think for next week, we could potentially at least resolve this case to let him go, figure out what he needs to do in Escambia.
That sounds like a grand idea.
Well, the real issue that I think we have is on 4/16 of this year, the Department of Corrections filed the third amended violation report alleging new violations, which include failure to comply, refusal to submit, and failure to report, absconding, and failure to allow the officer to visit the home, employment, or elsewhere, and a warrant has been issued based upon the addendum. So that's probably going to have a material impact on your ability to prosecute the case there in Escambia County.
Vis-a-vis a no bond, you mean?
Yes, sir.
Okay. Well, I would handle that with an order to transport, I imagine. Ideally, you'd leave them out until next week, and we can resolve the whole case, perhaps. I don't know if you want me to speak to the allegations. I know about some of them, of course. I don't know about the absconding. We could put my client under oath. I don't know if you're willing to, listen to that, hear that, or simply leave them out until next week, and we'll be back,
Well,
when we're all then.
I've already signed the order revoking his bond.
No, I understand, Judge. I do.
Now, if you feel there's other remedies, then you can explore that and bring it up before the court. But after reviewing that, I made the decision based upon that.
No, I understand. Are you inviting comment now in an effort for me to change your mind on the bond, or not necessarily?
If you feel like you've got some grounds, then I'll listen to it. You know me, Mr. Barnes, I'm always willing to listen.
Yes, sir. Yeah, sure. I just didn't want to plunge ahead, with all due respect to you. Judge, with regard to the failure to submit samples, I do know that my client has had for many, many months, maybe his whole life, an inability to kind of urinate on the spot. And this has been an ongoing thing when he reports there. We've requested if he could simply give a blood sample, immediately report to a lab for that, and that's been turned down. I don't know about the absconsions. If any of this is making purchase with you, I put my client under oath and have him speak to that.
Well, I'm not sure that that's fair to the state.
I would object, Your Honor, just in this sense. It seems like we're kind of having like a quasi-bond hearing, and I haven't had the ability to even talk with the probation officer about this. This just came across yesterday. But in looking at it, I mean, there's an allegation of absconding. There's an allegation that the defendant did not allow the probation officer inside of his home on April 8th of 25 and April 10th of 25. Given this, Your Honor, I think the appropriate measure would be to remand the defendant into custody because of the revocation of the bond, and then we can address and make these arguments on 424 if we don't have a resolution to this case. But as of right now, the state doesn't really have a means to combat any of the allegations or any of the statements that the defendant could make, simply because there was no notice of any bond hearing or any discussion of the veracity of the allegations in the report.
I understand the state's position, Your Honor. I do. Of course, we didn't have an opportunity to address the court either when the court signed the revocation, but that's how it goes. We all know that. So if we could come back on 424, we'll take a look at it and try to resolve the whole thing.
We got room on 424 in the afternoon? All right, we'll set this at 2:30 on 424.
Thank you, Judge.
All right.
Yes, sir. Thank you, Your Honor.
All right. We have a couple of folks here on the docket that are listed with no attorney. Everybody's entitled to have an attorney. If you can't afford an attorney will be appointed to represent you at the state's expense. To do that, you've got to complete an application for that appointment. And it's a crazy little government form, so it's a little confusing. What I ask is that if you want to do that, you fill it out here today, pass it back up, I look at it, and some of the areas that mistakes are commonly made, not because, because it's a goofy government form and it's easy to make a mistake on it. If I hadn't been doing this for all these years, I would probably be scratching my head how to fill it out. So as I call you up one at a time, you can let me know if you want a lawyer. The state may have an offer to resolve the case, and if you feel comfortable that you can accept the offer without the help of a lawyer, then you can do that. I can answer questions about what does that mean, how does that work, but if you have questions about what are the consequences, how may that affect this, that, or the other thing, I can't answer those questions because those are questions that a lawyer would have to answer for you, and I have to remain neutral in the case. I'll call you up one at a time, and we'll have a brief discussion. Jamie Cron, C-R-O-N. All right, you're here today without a lawyer. Do you want a lawyer to represent you, or you want to hear what, come on down, or do you want to hear what the state has to say first?
Hear what the state has to say.
Your Honor, in looking at the violation report, it appears that the violation is based on a failure to pay fines and court costs. He has $1,015 in arrears on the fines and court costs. And then there's also the special condition of 24 hours of community service work. The state, if he is wanting to resolve this today, would offer to convert that community service work to the statutory rate if he wants to buy it out, and then give him until June 17th to make payments on what he is owed. This is just simply a financial violation, it appears, in the community service. Or he can admit the violation. We would adjudicate him guilty, credit for time served, revoke and terminate probation, Your Honor.
Probation?
He's completed his community service hours and made all his costs and fines.
Oh, well, then we would dismiss the VOP and terminate probation at this time, Your Honor.
VOP is dismissed and the probation is terminated. Thank you very much.
Thank you.
Billy Oscar Lane. Lane. Billy Oscar Lane. Looks like the mail was returned from the address, but of course I can't see it. Hold on. Department, any contact with the defendant?
I've had no contact with Mr. Lane.
I was referring to the department.
Oh, sorry.
It's okay.
Sorry, Your Honor, what was your question?
Any contact with Mr. Lane?
No, sir, he failed to report as instructed, there's a probation officer.
All right, enter no bond capias, please. Samantha Joe Lucas, please. Is she in the county jail? Lucas?
It looks like she was just booked yesterday. So I don't know if she would have made it on the transport
So it was on something other than this?
Yes, Your Honor, it looks like a new law violation.
All right, so we'll reset this to our next date. Do we have a case number on the new case yet? Or I guess you said it was yesterday?
It looks like she was booked yesterday at 7:25 a.m.
So she just had her first appearance today. So it looks like she's got an ORB as well on, at least the website shows that there's the new case and an ORB. Looks like that's related to a POP and a CT case. So, we'll just reset this to the first date in May now. May 15th, those are 2/3. No, say the June 12th. All right, Steve Mercado Smith. Steve Mercado Smith.
I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties.
So
If
simply
you ever
remove
find
it from
yourself
the
in a
docket,
jam, please give us a call.
He'll
We're here to help you
repopulate
out.
when the warrant's served. All right. Mia Watson. Good morning. You're here today without an attorney. Do you want an attorney to help you or want to hear what the state has to say first?
Yeah, I want an attorney to help, please.
Okay.
As a friend of the court?
Yes.
Thank you.
Judge, if I can make
Yes.
So I've spoken with probation. It looks like that Ms. Watson's complied with the terms of her probation and everything except court cost. And the recommendation would be to go ahead and have the court revoke and terminate her probation and send the outstanding cost to a civil judgment or lien. And that would be the state's recommendation this time. She's substantially complied with the terms.
Okay, so so her termination date is when?
May 12th.
It's coming up in less than a month.
All right. And so the department filed the petition, filed the violation because she was within the period of time with the outstanding costs. I guess the court's concern is if the state's agreeing to do that, you're suggesting that you believe the defendant does not have the present ability to pay.
That's correct. So she had other things and requirements that needed to be met, whether it was restitution and then there was some other
So
requirements
if you agree she doesn't have the ability to pay, I'm not comfortable revoking. I'm willing to say she doesn't have the present ability to pay and simply allow her to terminate with outstanding financials.
That would be ideal. That would be appropriate in the situation.
And so we just dismiss the violation and allow her to terminate with the outstanding financials being driven to collections.
Yes, sir.
Department, you on board with that?
Yes, sir.
Okay, so the violation is dismissed. You'll terminate on your regular date and your outstanding financials will then go to collections, okay?
Okay,
All right, thank you very much.
all right. Have a good day.
Yes, ma'am. All right, I'm not, Mr. Nopes. Good morning, Mr. Nopes. Hustling back from Walton County, huh?
I did, Judge. Got behind somebody, 47, 48.
Better than a tractor, Mr. Nopes.
Well, I know. Well, I will tell you this. I'm not passing anybody. I mean, to me, as long as I stay in my lane, I was listening to a CLE, getting CLE credit, just enjoying my day.
I love
And I
it.
knew you wouldn't be mad with me, as long as I was safe.
Well, and also, you let me know where you are first. I'm okay with that.
I've got Harley Faison.
Yes.
The judge, the state had tendered a PTI, and she wants to accept it. assuming that the supervision will be transferred over there?
Yes, she'd have to report here, and then she'd be taken care of in Santa Rosa County.
So
Okay,
they
that's fine.
release you, you gotta come to Fort Walton, okay?
Okay.
All
Right, and so before you leave, they'll give you reporting instructions. Probation is here. Before you walk out, they'll hand you a paper and tell you what you need to do.
Okay, all right.
Okay?
Thank you.
Is the PTI complete?
When you say it's a complete bill,
Probation?
has not signed it.
Okay, so I think that she won't sign it here. They'll have to go to the office and do their intake and that sort of stuff. Is the state agreeing to release the, is there anything else holding the defendant?
No, she had a little misdemeanor, she took care of that.
State agreeing to release the defendant based upon this, and then we'll set it for a status date to be sure the PTI paperwork is done?
Yes, sir.
Okay, so we'll set that for June 12th.
It's already set for May 12th for your trial.
Yeah, we'll leave it on for May 12th for status, Mr. Nopes, and if the PTI is done, then it'll fall off the docket.
Very good.
Okay?
Where do I give this to probation, probably?
You can.
Yes.
Take it to the office.
Mhm.
Just wanna do it right.
Mhm. She can be released on the minutes.
You do realize that that's what the jail would say anyway. I had an order setting a bond, this has been 2 years ago, signed by a judge, and the jail said, the minutes don't agree with that order. I said, but that's an order, it's a certified court order. And I said, we don't care. Anyway, oh, that was interesting. Judge, I then have Dana Melson. Judge, over the weekend, Marty Notes on behalf of Dana Melson, 23 CF 1941. Judge, I was just appointed March 23rd. Over the weekend, I received Dr. McDonald's report. Dr. McDonald says that she is not competent to proceed.
Yes, sir, I've read the report. Does the state agree to accept the report?
Yes, Your Honor.
Just out of my mind. Oh, would you please give this to the state's attorney?
Glad to.
Is
After I
this
make a copy of it.
Is this insanity before or after or during the trial?
She says, currently, you're not competent.
The habeas corpus practice.
In any event, Judge,
Yeah. I'm not the only one that knows.
Yeah. Does the state accepts the report, and according to the report, the least restrictive environment would be a commitment to the Department of Children and Families for restoration? Does the state accept that?
That's correct, Your Honor.
Okay.
This is where the procedure begins.
So,
Have a great day, assholes.
you two.
life gets interesting. Judge, I've got,
Yes, go ahead and set this for a 6-month review, please. And Mr. Nopes, if you'll tender an appropriate order determining her incapacity, please.
I've got Mr. Purnell, 24 CF 2414. Judge, I was appointed March 26th. The state says that their notes showed that it was on for today for status. I have not looked at the minutes. I've not had a chance to pull up and look at the minutes from the last court date. But I have spoke with the state, and I believe they're okay with me asking for a continuance with the understanding that I think Mr. Koch had already scheduled depositions but had to cancel because I guess a conflict would come up. So I'm simply gonna have my staff reset the clear date, reset the depots and issue some, just copy what more or less what he's already done and get it going and get it on the calendar.
Okay, so reset the depositions, because there were a number of them, actually.
Right.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, I think. Ms. Sandler.
The state will find a date. I believe that if we get depositions done, we'll see a resolution of this case, Your Honor.
All right, because, all right. Do we want to set this on to the next docket for status? Or do you think that that's reasonable, considering we have 12 depositions that need to be set and conducted? I don't want to just set it on another docket when that's not a realistic outcome, and that just takes away from the time that everybody has to move the case forward, if that makes sense. I'd rather just check a box to check a box. You think you can get them set and completed by then?
What is your next pretrial?
It's 5/12, Mr. Nopes.
I don't see.
Ms. Sandler?
I'd like to leave it on pretrial. I will try to find a date before then that we can perhaps get all of those depositions done. Since I don't have a trial in Judge Clark this cycle, my calendar's opened up a little bit, and I will work with Mr. Notes to try to find a date in which we can schedule all those depositions before the pretrial.
All right, well, let's do this. I'll put it on for 5/12, but I expect you all to work together, and if you can't get them set, then there's just no reason to bring everybody back just to do this again. Because I'd rather move it on, move it on to a more certain date when we can make something substantial out of the case, instead of just bringing it back to check in, if that makes sense.
Absolutely.
So y'all work together and schedule that, and then if you need to do a scheduling order to cover that, just you work together and produce a scheduling order, send it to me, and I'll sign it.
We don't need an order yet. We
Okay.
work on it.
Okay.
I promise you.
All right, so we'll set it for 5/12, and we're gonna call that status, so that if you need the court's intervention, I can do that. Otherwise, it can roll off if you get things set, and you just send an order of the continuance for the next dates that we need. Okay?
Thank you, sir.
Okay? All right. All right.
Thank you, Judge.
Thank you.
And
Judge.
that concludes my business with the court this morning, if I may be excused.
Yes, ma'am. Thank you very much.
Thank you.
The last case I've got, Judge, is Michael Jermaine Thompson, 25 CF 211.
Yes, sir.
Judge, I had filed a motion to modify his bonds.
Yes, sir.
I will also share with the court that he was arrested January 29th, and yesterday, the state filed the charging document information. And I think that rule changed to where they're required now to file within 60 days. So yesterday was outside of the 60 days, I think. January 29th, February 28th, March 29th. So I'd ask the court to consider that as well when the court decides whether or not it will modify his bonds. He tells me that he does not have any money, either to hire a lawyer or even post a bond, but he thinks, he's fairly certain he can go back to work if he can get out of jail. And he's asking the court to modify the bond to where he could do a signature bond and have a monitor, a GPS monitor. And we understand that the court could set whatever the lowest amount is on the GPS monitor, but that's what he's asking for today, Judge.
All right. State?
I haven't had a chance to see a copy of the motion to modify or reduce the bond.
It was filed on 3/28.
I was trying to look for it. I wasn't able to pull it up either on the website. argue that the bonds that were established are appropriate in the case. This incident took place at a location that is known to have some criminal activity. There's no trespassing signs all over it. Mr. Thompson went there with fentanyl to provide to another individual at that location. Just based on the types of drugs involved, the location of the incident, the surrounding circumstances, and based on Mr. Thompson's prior criminal history, the state believes that $35,000 cash or professional and the $5,000 cash or professional and the burglary charge, Your Honor, would be appropriate. Mr. Thompson, at this point, scores for state prison. That's what the state would be seeking in this case.
And what is that score?
The score is, comes out to 56.9 points for lowest permissible sentence of 21.675 months. So this state would ask the court to deny the motion.
Further arguments, Mr. Nopes?
I'm sorry, sir.
Any further arguments, Mr.
No, sir.
Nopes? So the current bond condition is the 5,000 on the structure and 35,000 on the distribution and an ROR on the POP, correct?
Correct.
The court denies the motion for modification.
Yes, sir, Judge. I'll be out to see you after I get the discovery, okay? Thank you. Judge, I believe that's all I've got.
That's all I show, Mr. Nopes. Thank you. See you later.
Yes, sir. Take care.
You as well, sir. Mr. Catalanic.
Yes, sir. Thank you, Judge. Sorry I'm late. I called your office, sir.
Yes, sir. No, I got your message. You're all good.
Thank you, sir. Your Honor, I just have one case on the docket today. It's Mr. Demetrius Warmble.
Yes, sir.
WARMBLE, case number 23CF2473. He's got two case numbers, but we're only here on that one. It's the BOP. And Your Honor, I did a motion a while ago. It's a motion of limited representation, if the
Yes,
court
sir.
allows me to. Your Honor, and based, what I would like to, well, we'll wait for, Mr. Warmble.
Yes, sir.
Here's Mr. Warmble, Your Honor. You know, Your Honor, what I would like to point out to the court is he's never failed to appear. I know it's a VOP. He's been incarcerated, I believe, since March 3rd. He's been incarcerated for approximately 45 days, Your Honor. He's a long resident of Okaloosa County. It's a offense that he committed, Your Honor, allegedly, possession of fentanyl. It's personal use, he wasn't selling. And he does score out to 22 months in jail. That's why we believe he's not a flight risk. I don't think that the state is, I think that the state is opposing our motion, Your Honor, but we would like to be able to bond him out with a reasonable bond on the BOP. I know he's not entitled to a bond, but we're still pleased with trusting the bond on this case. It's for personal use that he was using it. He wasn't using it to also has a job, Your Honor. He's done everything else he was supposed to do during that time, Your Honor. He abided by all his terms, but he may have an addiction problem, Your Honor, but we pled him not guilty.
State?
Your Honor, the state would object to modification or reinstatement of bond or establishing a bond on the BOP. It's a very, this is, it's the same behavior that he's on probation for. And it's, like Mr. Catalinick said, it's a fentanyl possession. He scores 65 points, so it comes out to 27.75 months, lowest permissible prison sentence, and the state's going to be seeking Department of Corrections time on this case as well. So, just based on the criminal history and the similar nature and the facts that the behavior wasn't changed or on probation for distribution and use of narcotics, and then found in possession again, filed on probation. I just believe that no bond is appropriate now.
Your Honor, I also have an affidavit from one of the witnesses that he was filed with the state as well that states that my client was not aware of the possession. And I have that affidavit that was presented to the state as well. I would like to present it to the court if the court would like to take a look at it.
I'm sorry, so there was a witness at the time of his arrest in the new case that says he didn't know the drugs were present?
Correct. And the state reviewed, the state took a look at it. As a matter of fact, it was addressed to the state.
It's been a minute since I read this, but it seems to me that the car was stopped because there was allegedly illegal tint, and he was the passenger in the car. And when they approached the car, there was the strong odor of burnt marijuana. There was in plain view, prescription marijuana containers, but there was marijuana throughout the car. And then when they went to search the car, it's alleged that when he got out of the car, the fentanyl was in the seat under him where he was sitting, is what seems to me is it my memory correct of the identity of probable cause? Is that pretty close, or
Yes,
am I
sir.
wrong?
That's correct.
And so the affidavit says he didn't know he was sitting on it. Is that what the affidavit says?
The affidavit says that he didn't have knowledge of the fentanyl in the car.
And I have that, Your Honor, for the court. It's only 6 lines long if the court wants to take a look at it.
It doesn't say how this individual would know that he didn't have knowledge. It doesn't say who it belonged to. It just says that Mr. Warmwell didn't know about it.
And that's correct, Your Honor. That's really, I mean, from our perspective, Your Honor, that's a really strong statement for a witness to present. That was there.
Well, I mean, this is not a VOP today, right? This is just the bond hearing, right?
Yes, sir.
And according to the VOP, he's not employed. but according to the first appearance paperwork, he is employed. So where is the defendant employed or to be employed if he's released?
Speak up.
Maintenance man at Wendy's. Walton Beach on racetrack.
Why wouldn't the probation, and these are directed to your lawyer, not to you, why wouldn't the probation office know he was employed? Because they're saying they have no employment history for him on the violation report. And if you want to whisper in his ear, because I don't want him to potentially implicate himself.
Probation officer knows, Your Honor.
What? So is the witness the driver of the car or somebody else, Mr. Snell?
I didn't recognize the name. I'm pulling it up now to see if he's
Jacob Gomez is his name, sir.
I don't have him in my system as a witness to the case. So I don't have any idea how this gentleman would know that information.
So on this charge, the first appearance judge gave a $1,500 cash or professional bond, but then violated the probation based upon the new charge. Right? Is that, and then subsequently, the department filed the violation report. And the violation report says that the department doesn't believe, and I'm just going to read it, demonstrates a, I think it's blatant, but it says blatant disregard to the court's authority and continues to sell and use narcotics. Narcotics, fentanyl, deadliest drug, therefore it's the officer's recommendation defender's probation be revoked and sentenced to a maximum prison sentence. And it indicates that there's a number of conditions which have not been completed and under the current term of probation as well. So given all of that, I mean, I'll let you investigate further. I'm not saying I won't grant that, but absent some additional stuff, I'm not going to back up from the first appearance judge's determination of no bond on the VOP. Okay?
Yes, sir. Thank you, Judge. That's all I have, sir. Thank you.
And if you can work with the state on that and reset it as soon as possible after you have a chance to work through that, I'll rehear that. You know I will, Mr. Cadillac.
Yes, sir.
Okay.
Thank you, sir.
Okay.
Thank you.
First day in June. All right, Mr., who wants to go first over with y'all?
Your Honor, I'll call the people I have in the gallery right
Okay, please do.
now. First, I have Lee Lucas. Mr. Lucas is present and approaching, Your Honor. He's on today's docket for a motion to dismiss. I'll turn it over to Mr. Gomez.
I'm aware,
Okay.
there's no response by staff part of Mr. Collins.
That's correct, Your Honor. I believe Mr. Gomez was going to contest this motion.
Okay.
That's correct.
sorry, just a momentarily, who is this?
This is Levy Lucas, 24 CF 1010.
I apologize.
He said there's computer issues.
And did you provide an order?
I have not, because I did not get confirmation that that was what the state's response was going to be. I will submit this and the following case are both going to need orders, then they will be submitted later today.
All right, all right. It's granted.
Call me. Okay. You too. Next I have, Lee, don't forget, I think you have court on May 12th on another case. Okay. Next I have Christopher Marcus. Mr. Marcus is approaching, Your Honor. We had filed a motion to return property. What had happened with Mr. Marcus's case, when he was arrested, there was a cell phone that was seized as potential evidence. We filed a motion asking the court to order that return of that evidence, or the phone, because law enforcement to date has not sought a search warrant for the phone. It does not appear to have any evidentiary value here. Mr. Gomez also informed me that the state would not be objecting to this particular motion. This is the other case that I was saying the court would need an order.
That's correct, Your Honor. The state has no objection to the return of the cell phone. In this case, it has no bearing on the possession of controlled substance charge.
All right, motion's granted.
All right. Very good. All right. It'll probably be a Monday. Okay. Next, I have Ryan Martin. Your Honor, this is Ryan Martin, present and approaching. Mr. Martin is actually in the process of performing his community service work. He has done some, he's still working on it. This is being supervised through JCS, so we were going to ask the court to continue this to the last available date in June, I believe, to see if Mr. Martin can get everything squared away.
Objections?
No objections, Your Honor.
All right, Madam Clerk? June 19th.
All right. All right.
All right, thank you now.
Yes, sir. Your Honor, next on the docket, he's already been excused from court, was Ricky Minor. I believe Mr. Gomez was going to announce that the state was going to dismiss the violation and terminate supervision.
Yes, Your Honor, we received an affidavit from the principal of Edge Elementary. There was some confusion because we wanted to pay through probation, but I confirmed both with the principal of Edge Elementary as well as probation that they confirmed with the principal the restitution has been paid, and so we would dismiss this VOP at this time and terminate probation.
All right, very good, thank you.
Next I have in the gallery is Alexis Morales. Mr. Morales is present and approaching. He has reached an agreement to resolve this with the state, Your Honor. At this time, Mr. Morales is going to be entering admission to violating supervision. The agreed upon disposition is that Mr. Morales will be sentenced to 6 months at Okaloosa County Jail. That's with credit for all time served. His supervision will be revoked and terminated. He would be assessed a $100 cost of prosecution, $150 in public defender fees. He has previously been adjudicated on this case, and the state will stipulate that Mr. Morales has served the entire sentence.
That's correct, Your Honor.
May I approach?
Granted.
There's no objection.
Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. Klein said, you signed the written plea form.
Yes, yes,
And you understand that you're admitting the violation
yes, sir.
and waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
You're going to be sentenced to 6 months in county jail, credit for all time served, revoke or terminate your supervision, adjudicated guilty, have the additional fees and costs that were announced. The state stipulates that you've served that time. How much time will you need to get all your fees and costs paid? I don't know if you might have any outstanding fees or costs.
I don't know how much fees and costs I owe right now.
Your Honor, it looks like Mr. Morales is going to owe approximately, with the cost of supervision arrearages, it's going to be in the neighborhood of $2,800. If there was no cost of supervision arrearages, it looks like it would be about $1,600, $1,500.
24 months, good? All right, and the goal by giving that amount of time is to get you to pay them, right? And if you're making payments and you're whittling that down and you need some more time, ask. But if you're not making payments, don't bother asking, okay? The goal is to get those payments made. If you don't make the payments, there's gonna be consequences for you outside of court that can happen. So my reason for giving you time is to make those payments and get it taken care of, okay?
Yes, sir.
Okay? All right, so the court find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication. And he was previously adjudicated, I believe, right?
That's correct, Your
All
Honor.
right, all right, and that's a row can turn.
Last I have in the gallery, Your Honor, is Samuel Olmsted. Mr. Olmsted is approaching. So I talked with Mr. Gomez. The violation here is strictly financial for failure to pay restitution. Mr. Olmsted had been out of work for quite some time. He recently obtained employment with McDonald's. I don't want to admit that he violated because I don't think the state can prove that he willfully violated. He was actively trying to find a job. Mr. Gomez informed me this morning that the state would agree to dismiss this violation. Mr. Olmsted would agree to extend his supervision to 18 months with the condition that that supervision will automatically terminate upon the payment of restitution in full.
All right, that's the state's agreement?
It is, Your Honor.
Okay. So,
The court should modify his supervision to extend by 18 months.
so what we're doing is, this is an agreement to modify in return for a dismissal
Yes, Your Honor.
and automatically terminate if the financials are done at any time during that. So if he, wins the lottery tonight and pays it all off, then he can terminate, well, he can't terminate it tomorrow, it's a state holiday, but he can do it Monday.
Monday morning.
Okay.
Yes, sir.
All right, that's what you're agreeing to?
Yes, sir, Your Honor.
Okay. Raise your right hand. Swear affirm, testify truthfully in this matter under penalties of perjury.
I do.
All right. So you understand you're agreeing to modify your supervision for the 18 months.
I do.
The goal being to make those payments. But you're still on supervision, so if you have any other violations, you'd still be responsible for those violations during that 18 months.
Yes, sir.
And in return, the state will dismiss your violation. And probation has a question because they know if there's a question, they need to ask it.
Is it extended from his original term date in March or today's date?
The original term date in March.
Original term date in March.
Give him as much time as possible with the caveat that if he pays it, we'll dismiss it.
Okay.
Would the court consider waiving cost of supervision from this?
Cost of supervision are waived, given the circumstances. That way you can pay get all your money towards your cost.
Okay, thank you.
Okay? All right?
That's it.
All right. Mr. Koch, who do you have in the gallery?
Judge, if we call Mr. Lloyd Poole?
Lloyd Wolf?
Poole, and that's
Poole.
24 CF 434, Judge.
Okay, yes. Good morning.
Good morning, sir.
Your Honor, may I approve with Mr. Gomez? State
Yes.
Attorney?
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case
All
to
right,
trial,
so we'll reset this for a status conference on 5/12, and you will extend the conditional release until that time, pending that status conference on 5/12.
Yes, Judge, and just to be clear, Mr. Poole, that condition release, all those conditions are still in play. Of course, no return to that 7 Walnut Avenue address, no contact with the alleged victims.
I still haven't organized my one-time pickup for my property there because I haven't had stable living situations since this incident. So Judge Brown actually stipulated that I have one time to go and pick up my belongings from my parents' house at 7 Walnut, and I still haven't been able to do that properly.
Okay.
Just make sure you coordinate with law enforcement.
That was my plan.
And I have appointments available at my office on May 7th. I'm gonna give you my card, so you can come in and we can talk more in depth.
Yes, sir.
Okay? Excellent. Thank you, Judge.
All right, thank you very much.
12?
Yes, sir.
Judge, I have Dr. Cruz.
Cruz, please.
Mr. Cruz is present and approaching 22 CF 1041. Judge, this is primarily a financial violation. We would enter a denial and ask for a modification. And I'd like for the court date latest in June. I think that's the 19th.
19.
And
Objections?
No objections, Your Honor.
All right.
The modification relates to community service hours. I'd ask the court to allow him to pay those off at the minimum rate.
Granted.
And then he should be able to complete that by the time he comes back on the 19th of June. Yes, sir.
Very good. Thank you.
Yes, sir. Yeah, have a good one. Judge, the remaining matters I have are incarcerated.
All right, so who else do we have in the gallery so we can,
Judge, this is Miss Kara Wilson. She's actually on the arraignment docket at 1:30.
okay,
If the court wishes to go ahead and do that now.
if the state's prepared, and Madam Clerk, give Madam Clerk a chance to get there as well. You say Wilson?
Correct. Judge, she's currently on the docket without an attorney. She has filled out an application. May I approach the docket?
Granted. This is 25 CF 491, the 130 docket. Now, if you would, I'm probably gonna need a little better handwriting on that phone number. And if you've got a physical address or an email, because I don't think Madam Clerk's gonna be able to read that phone number. So if you got a physical address and an email, that will help us be certain we got good notice for you, okay? And just print the best you can that phone number. Okay. Those are like two completely different phone numbers that you wrote down there?
I gave you one that's my sister's and one is my friend.
All right.
So
Well,
you have 850-855-7059.
Okay, and then the other one is 974.
4020.
All right, it looks like you qualify, so I'll appoint the public defender to represent you. If the clerk says you don't qualify, they'll tell you why. And if you think they're wrong, get everything together that shows they're wrong, give it to your lawyer, and bring it to court with you next time.
Okay, yes, sir.
Judge, we would acknowledge the receipt of 2 count information, waive its formal reading and our plea of not guilty. Madam Clerk, when is the next pretrial that this is scheduled on? May 12th. If we can keep it on the May 12th date, we'll try to work it by then.
Perfect. Thank you very much. Thank you, Ms. Wilson. Good day.
You too, sir. Thank you.
May 12th, you said?
All right. Who else is in the gallery that we have? Just the rest of the folks we have are detained? Let's take just a comfort break and then we'll go to them. We've been here a while. Let's take 5 minutes. 5 minutes.
Prepared. Contact Dixie Dan Powell and Powell Injury Law. 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check
Yes, Judge.
All right, go ahead.
Yes, Your Honor. The allegations is we have outstanding restitution in this matter, Your Honor. Speaking with the state, we will be dismissing the violation, modifying and extending the probation for 2 more years, and including a monthly payment of $200 towards restitution.
Okay.
And I'm also going to ask if we can waive the cost of supervision, Your Honor.
That's the state's agreement.
Hold on one moment, Your Honor. I'm sorry. This was contemplated with citizens now.
Okay. So I believe that's no objection from the state judge.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You understand what's going on is that you're agreeing to extend your probation by the period of time. You're agreeing to make the monthly payment.
Yes, sir.
And if you agree to do that, the state will dismiss the violation.
Yes, sir.
So you understand that by extending your probation, that makes you subject to all the same rules and conditions for the additional period of time.
Yes, sir.
So if there's any other violations, you'd be subject to coming back to court on a violation as well.
Right. Yes, sir.
And you've also agreed to make the $200 payment a month.
Yes, sir.
And if you fail to do that, that would also be a violation. Are you going to be able to make that?
Yes, sir, I am.
Okay, all right. The court will accept the modification, and the state will dismiss the VOP.
Excellent, Judge. And just for clarification, Your Honor, may we waive the cost of supervision?
Cost supervision be waived so she can put her resources towards the payments.
Thank you, Judge.
Your Honor,
Yes,
is she extended from original term date or from today's date?
original term date, 18.
24.
I'm sorry, 24 months, 24 months.
Thank you.
Thank you.
Thank you.
Your Honor, this is Mr. Charles Little in 24 CF 2886. He's on today's docket. The court had requested the parties to present a scheduling order to the court. At the time that request was made to the parties, everything was fine. I subsequently then put in a notice, and scheduling the depositions for somebody who hasn't even been hired yet, kind of a problem. I did talk with the state this morning, and based on a suggestion from Mr. McKinney, I think the smart thing to do here would be to set the first depositions of the law enforcement officers in this case. There's a significant amount of medical personnel involved in this case. We don't have the medical records just yet. I believe it's 2 terabytes of data that we're collecting. We can do the law enforcement officers first. I don't think this is really going to turn a lot on their testimony, and I think we can get those depositions scheduled in June. It's just a situation where I was not anticipating putting in my notice and kind of having an unknown on the calendar going forward. I did prepare a schedule.
I still have that writ under my desk here.
Yes, sir, and I do appreciate that. But I did prepare a scheduling order, kind of just laying out some deadlines on things like jury instructions and pretrial motions, stipulations, and things like that. What I proposed to the state this morning was we present this scheduling order to the court, and then next week, once we get these depositions scheduled, we will present an amended scheduling order to the court with the actual deposition dates of the first round of depositions. And I think that way we can keep the case moving forward, keep it on schedule. It's definitely not something that's fallen off the radar by any means. It's just, this was a significantly lengthy investigation of over a year, I believe. So if I could approach with the scheduling order I do have.
State?
That's correct, Your Honor. We have no objection. And just for the court's information, the state is in possession of all of the medical records. The transfer is what is taking so long. There's approximately 2,500 pages of printed medical records. We also actually have all of the images, the x-rays, and other medical data that goes with that. Hence the 2 terabyte drive that's been provided, but the process of transferring that to those drives is a lengthy one. So Mr. Kleins and I have been in communication. As soon as his replacement starts next week, we're ready to go on and begin scheduling the depositions.
May I approach with this?
Granted.
Thank you. And I advised Mr. Little all of this at the jail when I met with him about 2 weeks ago. Your Honor, I was just asking Mr. Little if he wanted me to request to put this on the July docket or the September docket. I'll defer to the court, but I know Mr. Little would prefer not to sit around in shackles all day for a status update, certainly. He would request that the court continue to the September pretrial date.
I don't have any objection. The only thing is certainly, I guess, if we run into any issues with scheduling or that, we can bring it back before the court.
Absolutely.
And that's absolutely.
No, I mean, you've heard me say this, we need to look at the cases and discriminate the ones that we need to see, like, but if we're moving forward, we've got this, and we've got a scheduling order, we're moving forward on the case, there's no reason just to come and check the box every month, just to come and check the box. So if the state's okay and the defense is okay, with the understanding you can always ask that it be set on any docket if you need the court's intervention. We'll put this on the September 8th pretrial docket.
Thank you, Your Honor. That's all I have before the court, if I may be excused.
Yes, ma'am. Thank you very much.
Thank you.
Your Honor, this is Ms. Loomis in 23 CF 1594. We do have an offer from the state, and we were prepared to accept that today. That offer is for 24 months. An issue has come up with what credit she has. And that reason for that, Your Honor, is there's another case that was originally tagging along with this. I don't have that case number, but it was a child neglect case that supervision was terminated last September. I would like to see if the court would allow me to put this on for next Thursday. One of the issues, unfortunately, today is I can't see documents in Benchmark, and I didn't represent her on those previous situations, so I can't see any comments that were made. It does not appear that her bond in this case was ever technically revoked, even though she spent a period of at least 10 months in county jail.
1594 case or the other case?
The other case.
Give me that number. Let me see if I can see it on Smart Bench, because what's that case number?
Madam Clerk, do you have that? I don't, off the top of my head, I don't have it. Mr. Niddle represented her at the time.
23 CF 369.
Yeah. It doesn't look like her bond was released until she actually fled, but it looks like she was in She looks like she was in, I'm just looking at each of the minute sheets. For that VOP, which looks like the VOP started in the revocation started, looks like in December of 23. Does that sound about right?
Yes, Your Honor. I have a booking date of December 21st, 2023 to October 9th.
12/14 is when the motion to revoke bond. 12/15, the order revoking bond was issued. Looks like 12/26. The record of first appearance came through, and it looks like that was for 12/22. So it looks like hold on, let me look at the actual date she was booked in. 12/21 was the date she was booked in. And it was actually an order revoking bond. And so she should be entitled to time from 12/21 of 23. On that case, was she actually released after that?
I asked Ms. Loomis yesterday at the jail when the last time she was out of her own free will, and was advised that that would have been December of 23. However, she was also booked into the county jail on August 2nd of 2023 and somehow bonded out on October 9th of 2023. That's an additional 37 days. This is all stuff that I'm trying to get the state to agree to this, but Mr. Gomez's position is I'll agree to whatever she's legally entitled to. I'm trying to get her as much credit as I can here. She's okay with the 24 months. I'm just asking the court to put this over for next Thursday so I can try to either convince Mr. Gomez or make some kind of an informed argument to the court as to why the court should award.
Well, and I can understand your confusion, I mean, because I have access through our system, but it's very, very slow. And there was another order revoking bond back in March of 23. But then an ROR bond was posted, but then there was a transfer of another case. And then an admitted information. And then following on that, there was another, looks like, an order revoking bond again. So it's very confusing. So yeah, we'll set it off to the 24th so that you can do those calculations as best you can. And so what's happening, ma'am, so you understand, the part of the system's not working. I've got, just for lack of a better way, I've got a mirror image of the stuff, but only I can see it. The other folks can't. And so I'm just sort of trying to help, but I can't go through it. It's not as detailed and easy to access as the stuff that we all can ordinarily see. So Mr. Kleins has to do his job and adequately represent you and be able to look at all that. So we'll set it over so that he can do his best on that.
Yes, I
Mr.
appreciate
Cummings.
it, thank you.
I'm gonna look at all this. Okay, that's what I'm see. All right. Yes, sir.
Yeah, that's really confusing there, Mr. Klein. It says several, and I'm not sure. You know, it might be. Just saying that it might be two notifications. It says y'all couldn't have it might be a case number issue on the order, Mr. Klein.
And that's another thing that because I had noticed in the progress docket on the case that I do have, there was a motion to reinstate bond, but I never really saw a revocation, and so I was like, I need to figure this out.
So that, Madam Clerk the clerk can't take action if it's the wrong case number, so it might just be one of those administrative details. And so work with Mr. Gomez on that, and if it's one of those, the court's position. If there was an order revoking it and there's an administrative error where it just didn't, the clerk can't fix that.
Right.
And if it was in the intention, then I'll give credit for it.
Absolutely. And that's why I just wanted to pass it over. She's still going to have to do some time, so it's not like she's getting out today.
All right. Now, I'm sorry that was not about you, but we're having some struggles with the computers, and then we're trying to work that out.
Yes, sir.
Good morning.
Yes, sir. This is Mr. Lee, and he's on today's docket. There was a motion for an order to show cause. So in the meantime, Mr. Lee's bond was revoked for a GPS issue. I talked with Mr. Gomez, the alleged victim and the independent witness that we've been trying to depose for over a year at this point. They are already scheduled for a deposition in the beginning of May, the first week of May, before the court's next pretrial docket. Assuming that these individuals show up, and I have already had communications with the investigator with the state attorney's office, who I believe has had contact with these individuals, and I expect them they will be at this deposition. And if they're not, I'm sure the state will take the appropriate steps. Based on that, and the fact that Mr. Gomez would agree to reinstate Mr. Lee's bond today, removing the GPS requirement, I don't believe Mr. Lee really wants to press the motion today, given the fact that they apparently will be at this deposition in May, and the fact that the state would agree to allow Mr. Lee to be put back onto bond.
That's correct, Your Honor.
All right, so the state's agreeing to reinstate his pretrial supervision, removing the GPS monitor condition?
Correct. He would still be on CC sanctions under house arrest. But as long as those conditions are in place, we're okay with the GPS being removed. Just for the court's awareness, Mr. Kleins has provided alibi witnesses for the defendant. There is some other evidentiary issues that the state recognizes. That's part of the reason why we're agreeing to this, as well as the willingness of the defendant to allow us to simply look at the depositions of the witness and the victim. So given all of that, we feel like this would be the fairest outcome would be to reinstate his bond and put him back on the house arrest pretrial supervision.
But no GPS?
No
Yes,
GPS.
All right.
And obviously, we would provide an order to the court.
Yes, because given that circumstances, he's going to have to be instructed. I mean, y'all have seen the affidavit requesting the revocation.
I have, Your Honor.
And the court is just concerned that although the GPS was the precipitating event here, there are other allegations there. But if the state's stipulating to this, then I'll go along with that.
Yes, we are, Your Honor.
Okay, so reinstate the pretrial services, same terms and conditions with the exception of remove the GPS.
Yes, sir.
And you'll provide an appropriate order.
Yes, sir.
All right.
And
Very well.
we'll leave this on the May 12th docket, Your Honor.
All right. Order.
lectern had a slot machine, we had to go down. I don't know if this was done or not. Oh, as long as you can sit right there, it'll be okay.
Good morning. Good morning.
Judge, this is Brenda Darlene Watson before the court in 23 CF 2824. If I could pause at the lectern for just a moment. And Judge, as we go back on the record, the intention here is to reinstate Ms. Watson's supervision. This is the second violation of probation for positive urinalysis. Part of this agreement is a VA treatment program. She is a veteran from the Air Force. I've been in communications with Mr. Rivera, not for the Veterans Court program, but for contacts to get to Biloxi for that program. There is not a specific date on this agreement, and I wanted to bring that up with the court ahead of time. But the intention of the parties is that as soon as all that clears, that she would be heading to the VA treatment program, which obviously is out of state, and I want to make it clear with probation ahead of time that that is the intention of the parties.
All right.
So I signed an agreement with Ms. Watson yesterday that did not include all of those terms flushed out. So I've reviewed those changes with her. I'm in the courtroom here, and her son's present from Tallahassee, who's going to be helping Ms. Watson upon her release. She would be in a position to admit the violation of probation, and I believe the state agrees. This was originally withhold, would be a continued withhold. And reinstated supervision to complete the original requirements with a modification to include a VA treatment program or an equivalent inpatient substance abuse program with the standard $100 VOP and $150 cost of defense. And I did not put in bars to bed. Obviously, she would be released, and I did not put in do this within 10 days or 20 days because the intention of the parties is for that to happen as quickly as possible, but I don't know how long that process is going to take.
She's going to be moving to Tallahassee, is that right after treatment?
Her son did travel from Tallahassee to be with us here today in support.
I think your client has a question.
May I approach with the plea agreement?
Granted. If you'd raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? You may put your hand down. You heard what Mr. McKinney said, and you signed the written plea form. And he's told me that he filled in some extra details after you signed it, but he went over those with you just now, and you agreed to those. All right. Do you understand that you're admitting the violation? And that by admitting it, you're also waiving your right to a hearing where the state would have to prove your violation. And in this case, you will have the additional costs that were announced. Your probation will be reinstated, which you'll have to complete all the original requirements. It'll also be modified that you'll either attend the VA treatment program or an equivalent inpatient treatment program. Do you understand that? Okay. And the court will find the plea to be freely and voluntarily entered into and will accept the plea.
Is that with continued withhold of
It
adjudication?
is with a continued withhold.
Originally, I believe the cost of supervision was waived. We would ask the court to continue that.
Cost of supervision are waived.
Thank you, Judge.
Thank you, ma'am. Good day. Thank you, sir.
Do you have any questions for me? This is Mr. Jesse Reese Grace before the court. This is a violation of probation. We've reached an agreement. The agreement in 18 CF 24055 calls for Mr. Grace's probation to be reinstated to complete the original requirements. He is obviously admitting to the violation of probation. There is going to be a modification that includes 60 days in the Okaloosa County Jail with credit from the date of the felony violation of probation arrest, which is February 13th, 2025. There's a $100 VOP fee and $150 cost of defense. There would be an adjudication of guilt. He was previously adjudicated. Part of the original requirements was GPS monitoring, so that would be likely GPS hookup before release. May I approach?
You may. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay, you put your hand down. You heard what Mr. McKinney said, and you signed a written plea form.
Yes, sir.
You understand that you're admitting the violation.
Yes, sir.
And by doing that, also waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And in this case, he was previously adjudicated.
He was,
right?
Judge.
So you'll be reinstated to complete your original terms and modify to include 60 days county jail, credit for time served, with an arrest date of 2/13/25. So is that credit just from the 2/23/25, or is that all credit?
He previously served a prison sentence, so if we just say credit for time served, that would include that. So I want to make it clear that the modification is the 60 days in the jail from 2/13/25.
Okay, so it's a modification for the 60 days, which is resulting from this and his arrest on 2/13/25.
Correct.
All right, so it's 60 days from 2/13/25.
Correct.
Okay. Plus the fees and costs. Is that what your agreement is? Okay. Mr. McKinney answered all your questions. You satisfied?
Yes, sir.
Court find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Do you have any questions for me? Judge, this is Christopher James Whitney before the court. Mr. Whitney is here in 21 CF 848 for a felony violation of probation. We've reached an agreement. Mr. Whitney is going to be admitting to the violation of probation. He was previously adjudicated, but he's going to be adjudicated and serve 21.75 months Department of Corrections with credit for time served. That will revoke and terminate his supervision. There will be a $100 VOP fee and a $150 cost of defense. As Your Honor looks at the score sheet, I did make a correction that I did show Mr. Snell, which just takes off a misdemeanor that he, I believe, timed out or wasn't on the supervision. May I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Sir, yes, sir.
Okay, you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
And do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And by admitting the violation, I understand you to tell me that you believe that you violated your probation just the way the affidavit report says you did.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove you violated your probation the way the report says?
Yes, sir.
In this case, you were previously adjudicated guilty, but you will be sentenced to 21.75 months, Department of Corrections, credit for all time served. Your supervision will be revoked and terminated, and you'll have some additional fees and costs on top of what you already owe.
Yes, sir.
Mr. McKinney answered all your questions about the plea and how it affects you. You satisfied with how it's represented you? The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you. Yes, how much time do you need to pay your fees and costs after you get released, do you think? A year? Yes, you'll have a year to pay.
Get on payment plan.
Thank you now. Good day.
Judge, this is Casey Williams before the court in 25 CF 481. And this is on the arraignment docket. That's also on the 9 o'clock docket for a bond motion. But however, we're not going to do any of those things. We're going to enter a plea in 25 CF 481. The state has filed a one-count information in that matter. And to that, we're going to enter a plea of no contest. Ms. Williams is going to be placed on 24 months of probation with a withhold of adjudication. Special conditions would include a substance abuse evaluation and any recommended treatment, random urinalysis, 24 hours community service work. There would be court costs in the amount of $615 and a $150 cost of defense. May I approach?
Granted.
No objections to the score sheet, which reflects 16.8 points.
That's correct. I didn't remember if I gave you one or not.
What? You need a second? No, you can. If you need any questions answered, you can do that. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor, I do.
Okay, and you can put your hand down. Now, you heard what Mr. McKinney said, and you signed the written plea form he's given me?
Yes, sir.
Okay, how old are you?
32.
How far did you make it to school?
About 10th grade.
All right. You able to read and understand the plea form?
Yes,
Did you do that before you signed it?
I did.
And is what you read what Mr. McKinney just told me? Is that what's in the form?
Yes.
Do you understand by this plea arrangement that you're pleading no contest to the announced charges? And by pleading no contest, what I understand you to say is that you believe the state has the evidence necessary to convict you, and you will not contest that.
Yes, sir.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
I do, Your Honor.
In this case, adjudication will be withheld. You're going to be on 24 months of probation with standard conditions plus evaluation and recommended treatment, a random testing to confirm that, and 24 hours of community service.
Yes, Your Honor.
Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
I am.
Court will find the plea to be freely and voluntarily entered into and will accept the plea with a withhold.
Thank you, Your Honor.
Count 3,
I believe there was only one count information that was filed.
Right? I thought, the information that I have filed, that was filed on 4/9. This is Tacey Williams.
Tacey Williams.
Yeah, it was a 3-count information, count 1 and 2 were.
Are there multiple informations that were filed? The one that I saw was one count.
I know that there was a second information that was filed in the wrong case.
well, let me cue up my side because none of us can look at it right now, so hold on just a second. Let me look and see. 4, 8.
You're fine. You're good. Okay. They're just making sure the paperwork's right.
The information filed on 4/9 at 1:50 has 3 counts. Count 1 is POCS. Count 2 is POCS. And count 3 is legend, second-degree misdemeanor. Now, there was a previously filed information on 4/9, but it was filed in the wrong, that's the wrong case number, and that's actually an affray, so that doesn't apply. And then,
Not sure how that happened.
May I approach you, Madam Clerk?
The state will take no action, Your Honor, on counts 2 and 3. We'll just,
No pros?
no pros. Sorry for the confusion there.
Madam Clerk, does that make us good?
Yeah.
Okay.
and I've just amended the plea agreement to reflect count
Thank you.
1 as charged, count 2 no pros, count 3 no pros.
Yeah, thank you, Judge.
All right. All right. Thank you, Madam Clerk. As Ms. Williams, so you understand, everybody here knows I want to do it once instead of doing over. That's the reason everybody's speaking up to take care of it. That's the reason. So nobody's picking on you or anything like that, okay?
Thank you, Your Honor.
Mhm.
Judge, this is Miss Amy Ziska before the court. She has a number of violations of probation and some new cases that were on for status today. What I'd like to do. Judge, for the record, I'm providing Ms. Ziska a copy of the information in 25 CF 288 and the score sheet that's been provided by the state. But I'd like to move all these cases to the next pretrial date and have the violations of probation track with.
I think the 25 CF 288 is set on 5/12.
Yes, Judge.
And we were here today for status.
If we haven't formally entered a denial to the violations of probation, we would do that and ask for everything to track together.
I don't know that I can't. Okay. Denial will be entered in all cases, and we'll have them travel together to the 5/12 day.
Yes, Ron. 5/12. By that 5/12, it'll be 5/14. Thank you, Judge.
Mr. Koch, you have 2 left, is that right?
That is correct,
And what was her name?
Alice Lewis.
Lewis. All right, we'll get to you in just a second, okay? Thank you. Go ahead, Mr. Koch.
Okay. Mr. Sean Robertson? Judge, this is Mr. Sean Robertson in 23 CF 3258. I just have a brief moment for signature, Judge. Your Honor, this will be an admission to the violation of probation. My client was already found or adjudicated guilty. Sentence will be 11 months, 29 days, Okaloosa County Jail with credit for time served. There's $100 cost of prosecution, $150 in defense costs. All counts run concurrent and revoke and terminate probation. If I may approach the signed plea form and the score sheet.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, and you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that says to me that you agree that you violated your probation just the way the affidavit and report filed by your officer says you did?
Yes, sir.
Do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation in this case?
Yes, sir.
In this case, you'll be, you previously adjudicated guilty, and you're sentenced to 11 months and 29 days Okaloosa County Jail credit for time served. You'll have some fees and costs added to what you already owe, and your probation will be revoked and terminated. How much time will you need to pay all your fees and costs after you get released?
Maybe like 2 years.
All right, 24 months to pay. All right, Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied how he's represented you?
Yes, sir.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you.
The next judge, I believe we have Mr. Jared Smith, or Nelson.
Yes. All right. Good afternoon. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay. Tell me what's going on with your lawyer and what you want me to do about it.
I've written it all down here for you, Your Honor. I have logged the misconducts of Mr. Koch here. Can you, Mr. Judge, please?
Yes. Show it to the state first.
a written objection for KCF 188 as well.
For what?
I him to state a written objection for KCF 188, just in case he wants to look at it.
KCF 188.
Yes, that 188. That's a.
The 25 CF 180.
Yes, sir.
Okay.
I've included one in there for you as well.
All right. Mr. Koch, have you had the benefit of these documents?
Negative, Judge.
All right. I'll provide them to you so that you'll have the opportunity to see what the court's considering as well, and then they'll be filed.
I've also filed a formal complaint with the Florida Bar
I think
Association.
you stated that.
It's already been filed with them as well on Mr. Koch, on the same grounds as.
Yes, sir. You stated that in your writings, right?
Okay, thank you.
Mr. Koch, based upon that, do we need to inquire further, or do you have a request based upon the defendant filing a complaint against you with the bar?
Judge, can you have just a brief moment just to finish?
Yes, sir, you may.
Thanks, Judge. Thanks, Judge, for that moment.
Madam Clerk, there are two documents here. There is the Nelson supporting documents, and there's a second document, titled the second document as the defendant has titled it. It's the last page, I believe. Nope. That's, I think Mr. Cox, that's unrelated to that. Yeah, that's not related to that. Yes. Right, that's the second, that's his second document, so document that separately as he's typing. Okay. Mr. Koch, based upon those documents, do you have a request?
Judge, my only request is just to respond to those allegations.
All right.
I know there's I guess, an outstanding bar complaint. I guess in the abundance of caution, if we can appoint a conflict counsel, if there's an outstanding bar complaint.
All right, so based upon the inherent conflict created by the defendant filing a complaint against you with the bar, you believe it's necessary for you to withdraw without conceding ineffective assistance?
Correct.
Okay. All right. So you'll be permitted to withdraw, and I'll appoint conflict counsel.
Thanks, sir.
So Ms. Jaycat will be appointed as your counsel.
Thank you.
Okay. All right.
And we'll be back here on the 18th of next month?
I'm not sure when you're set. Hold on just a second. We're having some computer issues. We're set for May 12th pretrial.
Okay.
Ms. Jayquit will be notified. Now, whether she'll be ready by May 12th, I can't guarantee you.
All right. Yes,
Okay.
as long as I do not want any continuances in the case on my behalf. So.
Well, I can't tell her what to do. Newly appointed counsel, you'll have to discuss that with her.
Thank you.
All right, I think that takes care of that docket. Do you agree? Do we miss anyone? All right, so now we've got one person that the bailiff identified from the 130 docket who is here and present, right? All right. And what's your full name?
Alice Lewis.
And you're here without an attorney, right?
Yes, sir.
Would you like to have an attorney help you with your case?
Yes, sir.
All right. Do you believe you'll be able to afford one on your own?
Yes, sir.
Okay. Have you completed the application?
May I?
Yes.
I'm good, I don't need
Okay.
So, Your Honor, I had spoken with Ms. Lewis earlier. So in looking at this, she was charged with DWLSR, the 2C statute. And looking at it this time, we offered her a plea to the lesser included first conviction statute, which is 322.34 subsection 2 subsection A. And we would give her a withholding court cost. She had stated to me that she wanted to go ahead and accept that. I believe I kind of had that conversation with her in front of Mr. McKinney, and I think Mr. McKinney, out of the kindness of his heart, kind of let her know.
So essentially, they're saving you a little money is what they're doing. Okay. So you understand that,
Yes,
and that's a misdemeanor, right?
That's correct, Your Honor.
And that's a second degree misdemeanor.
Second
right?
degree misdemeanor, that's correct.
Is that a withhold?
Yes.
Okay. And what will this cost be?
I'm going to need to defer to the clerk.
$300 would be your court cost. About how much time you think you need to get that paid?
6 months.
Is that okay?
I'm completely fine. I had kind of instructed her, like, if you think you need X amount of time, maybe give yourself a little bit more time just to make sure. So that's she's
Because
okay with that.
if you don't pay within the time you said, then the clerk takes action, sends it to collection, and then it has a cascading event. There's a fee that goes on top of that, and then so if you think you get it done in 6 months, good. If you need a little more time, take the time. 6 months good?
Yes, sir.
Okay, all right, raise your right hand for me, please.
Sorry.
That's okay.
I'm kind of
It
nervous.
happens more than you believe, and
Yes,
if I,
sir.
if I was standing in that side, I might get confused too, so don't worry about it.
Thank you.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. Now, a lot of things just happened there. We exchanged a lot of words real quick legally. You understand the state's allowing you to plead to a second-degree misdemeanor. It's the same kind of charge that you were charged with a felony, but now it's a second-degree misdemeanor. Adjudication to be withheld. You'll have a $300 fee that you're gonna find that you're gonna have to, the court costs that you're gonna have to pay, and you'll have to do that within 6 months. If you don't make those payments, the clerk will send it to collections, and there may be other consequences. And by doing that, you'd have to plead no contest. And by pleading no contest, you'd be saying, I believe the state can prove I'm guilty of that charge, and I'm not going to contest that. Is that what you want to do? Okay. The court will find the plea to be freely and voluntarily entered into, and will accept the plea under the circumstances. Thank you very much.
Thank you.
Bye-bye. All right. I guess we've got, yes, Mr. Koch.
Judge, may I approach Mr. David Snell on a case on the afternoon docket?
Yes.
Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
So we ready to queue up Harry McWhorter?
Ready when you are, Your Honor.
Yes, Your Honor.
All right. Harry McWhorter.
Your Honor, this is Mr. McWhorter in 25 CF 735. He is present for a motion for pretrial detention. I'll turn it over to Mr. Gomez.
Yes, Your Honor. At this time, the state's going to be moving to pretrial detention. We went to subpoena the law enforcement officer in this case, Deputy Nash. And speaking with Deputy Nash, he has had scheduled leave for quite some time that started yesterday and extended through this weekend. He has family actually coming into town. Otherwise, he would have canceled his leave and had been here. We also have an eyewitness, as I was going through, Jalissa, who is a third-party witness that we're working on getting. I have a phone number for her. I've made some contact, or I've attempted to make contact. I haven't actually spoken with her. I'm going to be trying to get her here as well. And so for those reasons, Your Honor, we would respectfully request a continuance until next Thursday at 12:30 p.m.
Your Honor, Mr. Gomez did inform me that that was going to be the state's request. A couple of days ago, I did go to the jail and I talked with Mr. McWhorter at the jail, explained the situation, frankly told him essentially that my intent was to push back on these requests for continuances. However, given the nature of this specific request, that the lead investigator has a preset, essentially, family vacation, it is Easter weekend, I'm not going to in good faith stand here and say that's not fair to Mr. McWhorter. Certainly, he would like to have his day in court, absolutely, but it will be next week. The defense is not going to object to this continuance at this time.
All right. It'll be continued to that's the 24th, correct? At 12:30. All right. And as I understand the prevailing case law, that would be it. The state would not be entitled to another continuance.
Absolutely.
That's
Yes,
correct.
That's correct.
Okay. All right. All right. Very good. All right. So looks like we got a little time then. See you then.
No.